What is stopping convicted criminals being brought in to court for sentencing in the first place?
Yeah, well, whilst there are powers for dock officers and security officers to restrain or handcuff a defendant coming into the dock if there's a genuine fear of escape or violence to be inflicted, then there are powers. But I think dock officers are in a difficult position where you have a defendant like this who says, look, I just don't want to come into court without, offering any other risk. And short of them being sort of bound and gagged and dragged into the court, which perversely, I think, makes the proceeding once again all about the defendant and their likes or dislikes, the court's in a very difficult position. And this is not straightforward, for the opposition to say, oh, bring forward, a law. This needs very careful thought, and that's what the government, I know, is doing. So there are a couple of things I think that can be done. One, I think we should be using video and remote technology, which we use every day in court anyway, to beam into cells like this one in order to make sure there's literally no place for Letby to hide. I think that we need to protect and support dock officers with a strengthening of their powers so that they can act within the law in a way that can encourage and make more defendants come into court. And then thirdly, we need consequences from their failure. So if in this case, Letby will be the rest of her life in prison, perhaps not being released to an open prison or a different type of prison during her sentence because of what she did. And also with other types of offender, perhaps an extra sentence or an aggravating factor increasing the sentence, or the use of extended contempt of court powers. That is what I'm sure the government is considering, and I look forward to seeing their proposals as soon as possible.
Is there a philosophical consideration, I suppose, here, Sir Robert, which is that this is a particularly evocative and emotional case for very obvious reasons, and the justice system has to remain emotionless in how it functions. And so actually this is something of the heat of the moment scenario and situation which the public is feeling particularly grieved about. And I just wonder if that's helpful in decision making on a way forward from here.
Well, I think all of those considerations are helpful. What is also important to remember is that in cases like this, and it's not the first one this year, we had the awful murder of Olivia Pratt-Corbell in Liverpool a couple of months ago, where the defendant there refused to leave the cell. It's important for the victims' families to be able to, through their personal statements, explain the impact of the offending on their lives. And for many of them, they feel cheated if a defendant is not present in court to physically hear and see what is happening. And for them, there's a degree of justice in all of this that is then denied. It's like adding insult to the grievous injury and hurt that has already been caused. And therefore, I think it's right to try and reflect that aspiration much more directly by reducing the prevalence of this particular type of conduct, and I think it's right, therefore, that we look at measured reform in this area.
To what extent should victims have a say? Imagine a scenario, for example, where one victim's family wanted to see the offender face to face as they delivered the impact statement, but the next family member did not. Should there be any consideration of what victims' families want in this sort of scenario?
Well, you're right to say that there will be subjective views about this. I think in general, the principle of justice being seen to be done in the presence of everybody who is directly concerned with it, including a defendant, and then that information being made public, as we saw on the link today, which I thought was a very good use of the powers that I and the Lord Chief Justice introduced back in 2020, I think it was. All this is important in terms of public confidence and knowledge about the system. And I think when it comes to victims, for a long time, their views really weren't taken into account at all. I think the system sometimes was quite cold when it came to the treatment of victims. That's changed dramatically in the last few years. The victim impact statement is now a part of the court procedure, whereas it didn't exist, a dozen or more years ago. And therefore, times have changed, attitudes have changed, and we need to make sure that the court reflects that, consistent with the principle that it is the state, the Crown, that brings the case against the defendant, not an individual person. And I think getting that balance right and increasingly understanding the needs of victims, as the government is through its new victims bill, is absolutely the correct way forward.